I'm very pleased to be joined today by my colleagues from the Employment and Gatekeeper HR teams, Victoria, Regan and Elaine Abbs. They're going to take you through important employment tribunal cases over the last 12 months, events in employment law over the last 12 months, and perhaps a little look ahead to what we might be expecting over the next 6 months or so. Quick reminder to drop your questions into Q&A if you have any, and otherwise, without further ado, it's over to Victoria to start us off.
Lovely. Thank you, Catherine. Good morning, everybody, and thank you for joining us today. I'm Victoria Regan, a partner and head of the employment team. Okay, so if we go to our first case, this is really an interesting case where the appeal tribunal had to consider when dismissal might be appropriate when you're dealing with a serial complainer. So Mr. Hope was a senior policy advisor, just raised grievance after grievance, 7 over a course of 13 months. Line manager tried to deal with it informally, did not resolve the matters, and he actually then refused to cooperate when his employers wanted to elevate it to the formal process. And he actually then refused to even withdraw his grievances. He was warned that disciplinary action may ensue if his grievances were latterly found to be frivolous and vexatious. He also refused to attend a formal grievance meeting, and he was told that his attendance was a reasonable management instruction. Failed to attend, grievance not upheld, then invited to a disciplinary meeting for gross misconduct, finding that, having submitted numerous frivolous and vexatious grievances, this was unreasonable, and also his failure to comply with reasonable management instruction by failing to attend the meetings, and also just an overall breakdown in the working relationships. And as such, he was dismissed, brought a claim for unfair dismissal. And in this case, the appeal tribunal found that actually this was a fair dismissal based on Mr. Hope's conduct, and that this was a sufficient reason to dismiss him in the circumstances. So in this case, the company was acting within the range of reasonable responses. So this may well be welcomed by employers, but it's just important to realise that this is very fact specific. Next slide, please. And then on case of disability discrimination, we have a case here where Miss Daisy worked for Marks and Spencer's. She had a confrontation with a customer. The customer refused to wear a face mask at the height of the pandemic, and unfortunately, this triggered some memories of traumatic incidents that had happened previously, such as having to chase shoplifters and also witnessing an armed robbery. All of this without any sufficient training from Marks and Spencer's. She was unfortunately then off for a period of 5 months with anxiety and depression. And occupational health said that so long as Marks and Spencer's had exhausted all avenues for reasonable adjustments, then potentially they could terminate her employment under ill health retirement. So Miss Daisy was not happy with this. She complained, said there'd been a complete lack of action on behalf of Marks and Spencer's. They really failed to deal with abusive customers and the investigation. They even refused to disclose the investigation report for some vague GDPR reason. They offered support by way of employee assist programs, but that was it. And she felt really vulnerable. What they did do was they wrote to her and said that her absence, if continued, could actually result in dismissal. And she was after 5 months. So she actually appealed, but this was unsuccessful. So then she brought a claim in the tribunal for unfair dismissal. The judge was actually very shocked, and by the way Marks and Spencer's had dealt with this. Given their size, they felt that they just failed to address personal safety fears of Miss Hope, of Miss Daisy, and they thought that they were definitely acting outside the band of reasonable responses in dismissing her. They'd failed to show her the investigation findings. They'd failed to prove that they'd exhausted all avenues of reasonable adjustments, and they'd actually, in error, failed to actually show her the occupational health report before the dismissal meeting. So again, very, very shocked that they showed no interest in Miss Daisy's interest at all in her welfare or her return to work. And they actually did find that any reasonable employer would have waited a little bit longer after 5 months before dismissing. Next slide, please. And keeping with sickness absence, on this case, Mr. McAllister suffered from anxiety and depression and had quite a lot of absence, not always connected to his condition, but in the last 3 years before dismissal, he'd had 245 days off sick. And so he was actually dismissed. And in the period before he was dismissed, he'd been off for 7 months. So at that stage, he was unfit to return in any capacity. The company confirmed there was no more reasonable adjustments that could be made at that stage. And they actually felt that his absence was now adversely affecting the productivity and morale of colleagues in the team. So he was dismissed, then brought a claim. This went up to the appeal tribunal. And the key issue here for the appeal tribunal, when looking at whether this was a fair dismissal, was whether it could be objectively justified. Felt that HMRC could justify this. They felt that there was a legitimate aim, that being ensuring satisfactory attendance at work. And then the next stage, they had to look at whether the dismissal was proportionate, a proportionate means of achieving that aim, which they also found it was. They really focused on the impact that the absence was having on the business. This was key. Looked at productivity, management time and morale and the impact on that. Also, the fact that they're wanting to retain good customer service, and quite key as well, they had exhausted all reasonable adjustments. So when taking all of that into account, weighed up against any discriminatory impact that the dismissal would have had on Mr. McAllister, they found that the dismissal was objectively justified and as such did not amount to disability discrimination. Next slide, please. And I just wanted to flag this one up. This was one of 2 cases that came out in respect of redundancy selection and when you're dealing with pools of 1. So Ms. Morgan, she was a nurse employed on a succession of 1-year fixed term contracts. She was actually one of 2 nurses in the same department on the same banding, but the other nurse was actually on a 2-year fixed term contract, so a longer contract. Ms. Morgan found herself in a pool of 1 without any form of consultation, could not change that decision. She was placed in a pool of 1, no alternatives provided, so selection and dismissal inevitable. And the sole basis for placing her in that pool of 1 was because that there was less time left to run on her fixed term contract in comparison to the other nurse. So Ms. Regan said this process is unfair. It's unfair, and basically this then got to the appeal tribunal, and this is where the appeal tribunal stated the importance of consultation in a fair process, especially when dealing with a pool of 1. What they decided is that there must be consultation which takes place at a formative stage, and for that to be genuine and meaningful, the employee must be given an opportunity to make suggestions about their selection, about being placed in a pool of 1. Even if that means adjusting it, widening the pool, they must still be able to have that impact on the influence of any final decision. So as opposed to just being told they are in a pool of 1, they must be consulted about this and be given the rationale behind it. So this was found to be an unfair dismissal case because they found that the dismissal was effectively inevitable in a pool of 1. And it was actually determined before any form of consultation had taken place with the employee. So they found that this was not within the reasonable band of responses to choose Morgan on the basis that her fixed term contract would expire first. Next slide, please. And then on age discrimination, we had a plumbing and heating engineer, Mr. Robson, who was made redundant at the age of 69. There was a downturn in the business and a loss of a major client. So without any forewarning, any consultation, he was hooked into a 13-minute meeting whereby he was told that he was being made redundant. No other explanation apart from he was getting his 8 weeks notice, and that was that. No right to appeal, no rationale. After he was made redundant, Other staff were then asked to apply for voluntary redundancy. He then appealed and questioned whether it was to do with his age. He was the oldest skilled employee in Clarks. He was highly skilled and a qualified plumber and gas fitter, and couldn't really see any other reason. It also transpired that his nickname was actually Half Dead Dave, and he was called this on a daily basis by his colleagues as well as his supervisor. And when his supervisor was asked about this, he just fobbed this off as being just banter, no malice intended. After his redundancy, he also did find an advert on Clarks' website asking for a qualified plumber and fitter, which obviously Mr. Robson would have been able to do, but he was not offered this as part of the redundancy process. Well, there wasn't any process. So the ET actually said, well, this had to be age-related discrimination. There could be no other reason apart from age. He was skilled, versatile, had no misconduct history whatsoever, and he was the oldest at Clarks. So no other reason, but they also did make a finding that the banter of the supervisor and colleagues was also age-related and derogatory, and he was awarded £25,000. Next slide, please. And then on resignation, just an important reminder that resignations need to be unequivocal and unambiguous, and there might be times when an employer does need to question the context and to just find out what the actual employee wanted to do. So in this case, Ms. Cope had a fallout with her co-worker. The co-worker resigned, accused Cope of bullying. Ms. Cope then said, well, I'm going to go off sick if I have to continue working with this person during the notice period. The owners, it was a small factory, manufacturing company run by a husband and wife. They said, please, let's just act, please act professionally. You're both assets to the company. But this was really bothering Miss Cope. And so she wanted a meeting with the husband and wife, but unfortunately, the day she wanted this, they were at a hospital appointment and unavailable. This then heightened her anxiety at the time. And when she found out that they weren't there, she said, right, I'm done, left the factory keys on the counter and walked out of the building. Her colleague assumed, and the interpretation of the colleague was that she'd resigned, and the owners accepted that rather than checking it. So they didn't seek any further clarity. And it's important to note that that evening, Mrs. Cope did actually send a text to the owners just to explain that she couldn't stay any longer. Her nerves were shot and she'd never felt like this ever before. She also, the following day, submitted a sick note for 2 weeks for stress and anxiety. However, when she asked to return to work, the owners did not allow her to do so on the basis that they said she had resigned. Miss Cope said obviously she had not. She'd not even used the word resign. So at the tribunal, they found that this was an unfair dismissal and a wrongful dismissal. They did not believe that any reasonable employer would have taken the view that she had resigned, having not used the word resign, as I say, and also her subsequent behaviour was also inconsistent with someone that had resigned. So in this case, they pretty much jumped the gun in treating the words "I'm done" as a resignation. And they actually felt that perhaps they'd taken this as an opportunity to get rid of Mrs. Cope because of her dispute with a colleague. Next slide, please. And then lastly, I thought this was an interesting case just to really emphasize why emojis are becoming a growing harassment concern in the workplace. So what we had here, the senior female executive can't be named for legal reasons, but she was bombarded with peach emoji messages, which apparently are known to refer to a woman's bottom. So the boss had inappropriate behaviour towards her. She rejected his advances. Her boss was married with children also. He used to send suggestive text messages, request one-to-one dinners, calling her when drunk, and became very jealous when she befriended a male colleague. When she confided in a friend, she actually said he was behaving like a stalker. Everything came to a head when he sent a long text confirming his feelings for her. And so she raised a grievance, but unfortunately, she was actually harassed by the managers investigating the matter, who actually sided with the boss and made her out to be some kind of scheming femme fatale. She then resigned over a pay rise issue. And following from all of this, she suffered from serious PTSD, anxiety, and depression. So when this got to the tribunal, they found that, yes, this was sex-based harassment and victimization, and she was actually awarded £420,000. But in addition to this harassment and victimization, it made a further finding that the company was actually discriminatory and harassing towards her for the way in which they had conducted the investigation. So I suspect that this will probably be just one of many future cases involving the misuse of emoji messages. And I will leave it there and I will pass you over to Elaine. Thank you for listening.
Hello, everybody. I'm going to be carrying on by telling you about all the employment law changes and some relevant guidance and potential acts coming into force, which were announced during the time from when we delivered our last seminar. And I'm also going to be then going on to look forward to, or maybe not look forward to, but as employment lawyers, we like looking forward to things. They're going to be changing that the government have recently clarified, and you need to know about these. So just going back to 2022, the change that came about with fit notes, which most people will be completely au fait with, it came into force from 6th of April 22, when employers were able to be presented with a digital version of a fit note. Since July 2022, importantly, more healthcare professionals can sign them. Previously, it had just been doctors or anybody at the hospital who was caring for the patient, their patient. And as everybody knows, the NHS is highly pressured, so fit notes from GPs and fit notes from consultants taking a long time, so the government wanted to take pressure off the NHS. In my practice, I haven't seen anything digital that any employee has presented to their employer, but I do think this is going to be really helpful, and hopefully employers are already recognising that. So moving on to agency workers and strikes. For a long time, everybody's known that agency workers couldn't actually be used when there was a strike to fill in the gaps. But since July 2022, agency workers can now be lawfully provided. The unions have put in a judicial review of this legislation. And so probably within the next week, we're going to find out the result of that judicial review application. All of the unions have joined, all of the major unions have joined together for that. Next slide, please, Catherine. Pre-employment right to work checks. Importantly, everybody needs to know about this. Anybody employing workers or employees needs to carry out pre-employment right to work checks. And these are the ones from 1st of April 2022. These are the ways that you can do it. So number one, a manual right to work check. So that means if someone presents themselves to you physically at work and brings their physical original documents, that's a manual right to work check, and everybody who's employing people will know about that already. For British and Irish people who anyone's employing, a right to work check can be carried out using the identification document validation technology via the services of an identity document service provider. Those are both cost money. So manual right to work checks are obviously free. On the third option, for non-British or for Irish workers, the Home Office online right to work check, which has been enforced since 2018, is the way that those should be carried out. Fines are really high for anybody who's found not to have carried those out. So up to 20,000 per employee. And if someone should have known that somebody they were employing didn't have a right to work, there's a potential criminal liability and a jail term for 5 years. So latest government guidance on all of this is February 23, and I urge people to look at that. Next slide, please. Thanks, Catherine. So everybody may have heard, The retained EU law revocation and reform bill was introduced in 2022. It provided for sunsetting of the majority of retained EU law, which meant that by the 31st of December this year, the EU-derived law would literally go into the sunset, and it would drop off and just go. But that has been changed recently. On the 10th of May 2023, the government announced it was going to drop that sunset clause, i.e. this legislation, which included a huge raft of employment laws, which is why I'm mentioning it, is going to be around until the government announces this year a schedule of what they're going to keep. And this allows the government to scrutinise what they want to keep, rather than laws just disappearing, and that would have left employers with a vast amount of uncertainty. So moving on to employee data and monitoring, which is a different subject altogether. So the Information and Commissioner's Office has launched consultations to help employers. So on monitoring employees at work, if employers are going to carry that out. Currently, if you look at the ICO website, that you cannot see any guidance on this. So that's going to come in. So there'll be practical guidance for employers, and also there's going to be more guidance on data protection of workers' health, which is really important. We frequently in our practice get questions about this. So neither of these changes impose any new duties, but they're just intended to assist employers. And then very recently, in the last few weeks, we've had an announcement and a launch of ICO guidance in regard to data subject access requests, and the employers should benefit from this because it gives very much more guidance than was previously available, and employers tended to get it wrong when people are asked for their data, and then employers are liable to have fines. And so the whole uncertainty in regard to data subject access requests should be removed by this, and that guidance is available online. So next slide, thanks, Catherine. So exclusivity clauses in employment contracts came in last year, and that was for 0 hours workers, and they were banned, and for 0 hours workers. And so that meant that 0 hours workers were able to take up other employment and increase their earnings by that way, obviously. So anybody who's on a low income and who's in receipt of the no more than the lower earnings limit can now also take an employer to an employment tribunal if their employer keeps in the exclusivity clause in their employment contract and stops them from going to work elsewhere to increase their income. Calculating holiday entitlement is at the bottom of this slide. So for part-year and irregular hours workers, there's currently a great deal of uncertainty about how to calculate holiday entitlement and holiday pay, and that resulted from a Supreme Court judgment last year. And the government consulted in February of this year, and the consultation now ended, and we should have, as a result of that, some new guidance for these workers who work part of the year, such as an invigilator for exams, working term time in a school, or for anybody working irregular hours over a year. So contrast that with people who work part-time. It's easy for an employer to find out how much holiday pay and holidays somebody's entitled to. And the part-time workers often now end up with fewer holiday entitlements than somebody who works for part of the year. So that's clearly not fair. Next slide, thanks, Catherine. Minimum service levels at times of strikes. I'm not sure whether people need to know about this particularly, but it's been in the news that the government have wanted to maintain minimum service levels for the really important public services. And originally it was transport, and now it's health, education, fire and rescue, border security, and at nuclear installations. So the latter is pretty important, as are they all. But that legislation, watch this space, because there's some new changes to that proposed legislation. So at the bottom of the slide, I've written some important helpful guidance for employers which have come out in the past year. The ACAS guide on managing work-related stress, how to spot the signs. So that's for employers and employees. That was published in April this year. The government's also consulting on a draft disability action plan. There'll be much more guidance for employers in regard to employing people with a disability on how, importantly, to make reasonable adjustments. The Health and Safety Executive have also, as an organisation, they themselves have published very useful guidance for employers in making reasonable adjustments for people they employ with disabilities where health and safety will be an issue for them potentially. Next slide, thank you, Catherine. On sexual harassment, most people will know that the government have been trying to do something to prevent sexual harassment. So there's a bill which has now been accepted by the government. It was originally a private member's bill, and there's going to be, under this bill, when it's in force, a new duty on employers to prevent sexual harassment. And there's also going to be a duty to prevent third-party harassment, and there will be liability on an employer for third-party harassment in the workplace. So that's things like if you are in the service economy, you will be liable if a customer harasses someone who works for you. Which is, so there used to be this part of the Equality Act that prevented that. It was taken away around 2014. So third-party harassment is now coming back and will be part of the Equality Act 2010 in the end. So the government is committed to preventing sexual harassment in the workplace, and I put something about the International Labour Organisation's Violence and Harassment Convention. Next slide, thanks, Catherine. So here you need to know that the government response to menopause in the workplace report recommended some changes to the Equality Act, in fact, but the government didn't go that far, and a women's health ambassador for England and actually a menopause czar has been appointed, and that person will be responsible for information and ensuring that employers are informed about menopause and how they can make supportive measures in the workplace for their employees and to prevent women leaving in droves at a certain age, and to keeping skilled women in the workforce. Discrimination, the ACAS guidance 2022, just a mention of that as a tool for both employees and something as a resource for employers when somebody makes an accusation or raises a concern that they have suffered discrimination. So this guidance is something that will be a resource for both parties, and that was there haven't been much news about that, but it's helpful. Hybrid working. So hybrid working is something that some of you will be experiencing yourselves, and some employers will have enabled this during the pandemic. New ACAS guidance for employers and employees, which covers issues how to ensure remote workers are not excluded socially, not something that's talked about very much. And so it ensures employees can work safely at home. That's something that ACAS has provided, other than, well, the ACAS is a branch of the government, but ACAS it is used by the government to issue very helpful guidance. So next slide, thank you, Catherine. These have been talked about for a long time. Unpaid leave for unpaid carers, a day one right to request flexible working, greater protection from redundancy for expectant mothers during pregnancy, and extended protections for new parents when they return from maternity, adoption, and shared parental leave. Sorry, there's a lot of information in one slide, sorry. And neonatal care leave. So employees have been hearing on the grapevine about all of these things, but now the government has actually backed the private members' bills, which were bringing in the unpaid leave for unpaid carers, and the protection from redundancy, and the neonatal care leave. So we are all waiting to know when these are coming into force. So I made a note, and redundancy is not that the protection for redundancy is coming in 2024 at the earliest. neonatal leave April 25, and carers leave also April 25. So these things are, we'll be talking about these things next year, but it's just so that you know that those are coming in, they definitely, rather than being proposed and dropping off. And most employers will, and some employees will have heard recently talk about the right to request flexible working coming in on day one, rather than after you've worked for your employer for 26 weeks. So a day one right to request flexible working, watch this space. We don't have a date when that may come in. Next slide, thank you, Catherine. Diversity and inclusion, the government's published guidance for employers who wish to report on ethnicity pay gaps in their workplaces. We have now news that on May 24, 2024, that the Employment Allocation of Tips Act is going to be in force. So employers must parcel tips to staff in full without deductions, and staff can ask for their employers to provide them with all the information about tips. Next slide, thanks, Catherine. Sorry, I'm whizzing through because we're nearly at the end. So we have recently, in May, the working time regulations have are being looked at, and there's proposed reforms for record keeping, simplifying annual leave and holiday. 2P reforms are on the agenda. That's to do with consultation and representative. Post-termination restrictions, really important. The government has confirmed that it plans to limit the length of non-compete clauses in employment contracts to 3 months. I'd like to talk for a long time about how that's going to impact employers, but we don't have time, but do contact us for further information. Next slide, thanks, Catherine. Code of practice on dismissal and re-engagement, just so that you know that this code is being worked on now, and most people will have heard of some poor practice on dismissal and re-engagement. So there will be a code of practice to protect those who are dismissed and whose terms and conditions are threatened once they've been reinstated or at a lower, at a reduced employment contract in regard to their terms and conditions. So next slide. Thank you, Catherine. I was waiting for my logo of the sun because I quite like it. I was choosing it last night. So Summer Fridays, just to say, there's a growing trend of offering some working hours. Kellogg's, ASOS and PwC are allowing employees to leave at lunchtime on Fridays, subject to caveats such as having completed your work by lunchtime on Friday. So anticipated benefits, happier employees and retention of all your good people and increased productivity. Thank you everybody for listening. Sorry, it was a race through.
Excellent, thank you very much to both of you. Now I'm just going to whiz on to, no I'm not, there we are. It's important that we show you the disclaimer. This is a webinar giving you generic information. It doesn't constitute specific legal advice. Please do bear that in mind. If you do want specific legal advice, do get in touch with us afterwards. And obviously, if you have legal questions that don't relate specifically to employment or our Gatekeeper HR offering, then if you ask any of us, then we can pass it on to the relevant individuals. Okay, so let's see how we're doing on questions. One for Victoria, I think, on the Daisy case, would the outcome maybe have been different had the employer been smaller if we weren't talking about Marks and Sparks?
Good question. I think the answer really is everything's always fact specific, but the tribunal, I think, was particularly scathing of Marks and Spencer's, given their size and given the lack of training, lack of support, and just the ability to actually support her and make her feel less vulnerable. In terms of whether it be different with a smaller employer, I think what we would look at is the impact. And again, it's the impact that any such absence might have upon colleagues. So in a larger business, more easy to fill roles, and in a smaller, less so. However, I think the real crux of this was that they had only waited for 5 months before dismissing, and the 5 months that she was off was really directly linked to safety fears at work. So had they actually explored this more fully, so whether it's a small or a large company, they would still be required to explore this fully with the employee with a view to see if there are any adjustments that could be put in place. I don't believe they had exhausted all reasonable adjustments in this situation, and to really try and facilitate her return. And there's a real lack of that. So employers of any size must really consider adjustments, explore this with her, because the main concern was about her health and safety on return. And because they hadn't considered this, they just failed. So any size of employer would be required to do that. So I think perhaps it would still be an unfair dismissal, just because of this lack of dealing and exploration, but also the short period of time within which they took to dismiss. So sometimes it's better to pause and explore, and if necessary, get further occupational health reports nearer the time before dismissal.
Thank you, Vicky. We've got one participant who is firmly voting for Summer Friday. She'll be pleased to hear. Okay, another question. Elaine, one for you, I think. In terms of passing on tips in full, you might not be able to answer this actually, whether those are going to be subject to tax at source. That might be one for our tax colleagues rather than for us, but unless you do have an answer.
They will be, yes. As far as I know, the answer, I can pretty confidently say yes to that one.
Super. Right, now working hours in terms of 0 hours contracts. Contracts list specific hours with caveats along the lines of you may need to work hours outside of the specified hours to complete your role. Staff these days rely a lot on contracted working hours when asked to work longer to meet deadlines.
Mm-hmm.
And how is an employer expected to deal with that? So obviously, you know, all contracts do have that. Well, not all, but a lot of contracts have that. These are the expected office hours. However, you're expected to deliver your work in as many hours as it takes you to deliver your work, almost. And if people are putting their foot down and saying, no, I leave at 5 o'clock, where does an employer go with that one?
Well, you'll have to rely on your contract of employment as an employer. So most contracts will say these are your working hours, but subject to the demands of the business, you agree to working outside of those hours. Most contracts do say that. If it's a problem, then there needs to be a dialogue between the employer and employee about numbers of hours being worked. There's health and safety implications for people working really long hours, obviously because of the 48-hour restriction on the working time regulations. So people shouldn't be working over those hours. Talk to employees. And everyone needs to come to an agreement.
And I
so
think
no hard and fast answer. Just it's dialogue.
I think, and also in addition to that, is to explore with the employee if there's any reasons as to why they're not fulfilling or performing the work within that time, and consider if there's some form of performance or capability issues there as well.
Another question here, which I think you have answered, but perhaps it's just clarification. Slightly concerned that you might have suggested that employers had to undertake right to works checks using ID validation technology. Elaine, I don't think that's what you did say. It was one of the options available.
I had a small bracket. So I had a, sorry to Catherine, speak over you. There was a small bracket in the top one which said manual for everybody. You can carry out a manual right to work check for everybody. So that's acceptable. And I described, you know, what I meant by manual, which is, you know, when you have the original document.
So using the ID validation technology is one tool in your armory, but not the only one.
Exactly, and it costs money to do, but you can use it.
Okay, and we're rapidly approaching the end of the webinar. We've got one more question, I think. Given the non-compete clauses have gone up, given the non-compete clauses have been reduced now to 3 months, how can companies best protect themselves? How can employers protect themselves? So
it hasn't happened yet. The government actually held a consultation on this a couple of years ago. So it's been rumbling. So it may happen. So don't think that it's currently enforced. It is proposed that this happens. And in answer to the question, employers are going to put into contracts longer notice periods. That's what is the general consensus. and that's a way of getting around this.
I think also in addition to that as well is making sure that you've got really robust confidentiality clauses in there to protect your business. But in addition, there are other forms of post-termination restrictions such as non-solicitation and non-dealing. So if you could actually have strong non-solicitation clauses, which essentially stop the ex-employer from contacting and actively soliciting your clients and contacts, and perhaps a non-dealing clause, which actually prevents them from working with those contacts if they're approached by contacts and referrers, etc. So obviously to have those as well, that will obviously provide more protection, even if you find that you can't enforce or rely upon more fully with the non-compete clause.
Excellent, which takes us very, very neatly to 9:45. Oh, we may have had another one come in. Let me just check. No, okay. So I think everyone, if you're comfortable, thank you very, very much for joining us today. We hope that you found the session enjoyable and informative. If you do have other questions, whether general or specific, do let either Vicky or Elaine know. Their contact details are still on the screen, or of course you can get hold of us through the website or by the usual means. Elaine, Victoria, thank you very much indeed. Everyone else, we wish you a very pleasant day. Thank you for joining us.
Thank you.